Hey y'all, welcome. So today we are going to be going over some immigration news. Some good things have come out, and I want to make sure that you are aware of them. Okay, immigration news is always good to know because you want to know what is USCIS doing, what is coming up, so that you are prepared and you know exactly what is going on. Okay. I am U.S. immigration attorney Lillian Chukura, and I help my clients get green cards and citizenships for themselves and their families using the U.S. immigration law system. So let's get into it right away. The first thing you need to know, okay, if you don't already know this, the fees are going up. So on April 1st, any application that's received by USCIS on April 1st and later are going to have a different fee. Okay. So just be prepared for that. Know that it's coming. If you are almost ready to file your application, get everything you need done before April 1st so that you get to pay the current fees unless there are a couple fees that are going down. So if you are applying for citizenship, the current fees today is $725. However, if you wait till April 1st or later and you file your application online, you're going to pay 710 instead of 725. Now, if you're going to file your citizenship application on paper, it's going to cost you more after April 1st. So you really want to make sure that if you're looking at, applying for citizenship and you want that $710 fee, you want to file your application online. If you are waiting till then, just make sure you file your application online or you're going to be paying more come April 1st. Okay, so people applying on paper are going to from paying 725 to 760. Okay, that's a $50 difference between filing online and filing on paper. So you really want to make sure that you are absolutely filing online if you can. All right. And if you can't, file before April 1st so that you get that lower fee. All right. Now, that is the biggest thing as far as fees being lower. Now, let's talk about the fees that are going up. If you're applying for a green card, if you are applying for family outside of the US, so if you're filing an I-130, an I-485, an I-765, an I-131, all of those fees are going up. Okay. All of those fees are going up. So if you wait, the longer you wait, the more you're going to pay. So if you wait till April 1st or later, you're going to be paying those higher fees. Keep in mind that even though some of those fees are going up, so for example, the I-130 fee is going up. If you file the I-130 online, you're going to pay $50 less than if you file it on paper. So any forms that you can file online, it's going to be $50 cheaper than if you file it on paper. So USCIS really, really wants everyone to get a USCIS online account and file their applications online, especially for the forms that are available online. Remember, not all forms are available online. That's a big thing because you may think, okay, I can file my I-130, my I-485 green card application online. You cannot. Okay. You can't file the I-485 online, but you can file the I-130 online. So it really just depends on your particular situation. But just know whatever forms that are going to be able to be available online is going to cost $50 less online versus on paper. That's what you need to know there. And also, now if you're filing a green card application and you also want to file a work permit and a travel permit, you now have to pay separate fees for them. Okay, before April 1st, you could bundle those with the green card application and only have to pay the green card application fee, and you get the work permit and the travel permit included. After on April 1st and after, you're going to have to pay a separate fee for the work permit and a separate fee for the travel permit. So keep that in mind. One thing to know is if you already have a green card application pending, you are grandfathered in to having those work permit and travel permit included in those fees. So only people that file April 1st and after have to pay a separate fee for their green card application and their work permit. Oh, yeah, their green card application, their work permit, and the travel permit. But if you file before April 1st, let's say you already filed your green card application, you already got your work permit and it's about to expire, you do not have to pay a fee, even if it expires after April 1st. Okay, you're not paying an extra fee. You're going to be grandfathered in to the old fee structure where your work permit and your travel permit is included. All right, so don't go sending in um, fees because USCIS is going to reject your application because you do not need the fees. All right, so if you have questions for me, I know I didn't say this, but if you have questions about US immigration or the topics that I'm talking about, go ahead and put them in the comments. I'll be happy to respond to your questions. The next thing I want to talk about is the new update on visa overstays that want to do a change of status. So, if you do not know, before this new policy change, if you overstay your visa, you could not file a change of status. Okay, you can only file a change of status. So that's going from one non immigrant visa to another non immigrant visa. So, for example, going from a B2 visa, a visiting visa, to an F1 visa, which is the student visa. In order to do that change of status, you would have had to be in legal status. So, your B2 stay must have been valid when you apply for change of status. Okay. If it was not valid, USCIS will just go ahead and deny your change of status application. Now, with their new policy, if you already overstayed your visa and you go ahead and apply for a change of status, they may still approve your change of status if you can show that there were exceptional circumstances that led to you not being able to apply for the change of status on time. So this is a big change in policy because now it gives an opportunity for, let's say, someone that is in the US, because I have seen this happen. Someone is in the US on a B2 visa and they only overstayed and were not able to apply for a change of status because, let's say, they got into a car accident and were in the hospital and were not able to do anything. Right. So, in those situations, now USCIS is saying if you can prove that it was a exceptional circumstance beyond your control, they can still approve your change of status even though you already overstayed your visa. This is a big deal because there's so many people that overstay or were not able to get their change of status filed. Maybe they weren't able to get the I-20 on time because they were in the hospital, right? They couldn't provide the documentation required to complete the I-20 process to then file their change of status, right? But remember, this is exceptional circumstance beyond your control. All right. So if the circumstance is that you didn't have the funds to pay for the change of status, that's not really beyond your control. All right. It has to be so if it's just but there may be a situation where you did have a sponsor that was going to pay for everything. However, the sponsor passed away tragically, and it's beyond your control, and all these things happened. You may be able to still apply for that change of status. Again, if you're already overstayed, let me say this: if you have already overstayed and you do have an exceptional circumstance, you may not think it's enough to apply for the change of status. However, if you have already overstayed, it may not hurt to still apply for the change of status with the documentation and evidence of the exceptional circumstance, let USCIS say that's not enough. Okay, so minimum, you must have exceptional circumstance beyond your control. I have had conversations with people that they just did not do anything. There was no exceptional circumstance. There was no reason for them missing the cutoff time to apply for that change of status. And when you miss, again, if you miss that cutoff time, you're going to be in a situation where you are not able to get that change of status approved. And if you want that approved under this new rule, that is, again, it's a new rule. It's a it's amazing, right? It's amazing for people that are in certain circumstances and they just know, right? They know they want their change of status. It's just something beyond their control happened and they are able to document that and prove it to USCIS. They can still get their change of status approved. So this is something new. This is something different. This is something good. So that's always when USCIS does things that is good for my clients, for you all out there, I will always tell you, because this is such a big change in their policy that actually helps you. All right. Now let's talk about the next update, which is another good news. So USCIS has actually reduced their backlog the first time in like forever. Okay. As you all know, when COVID happened, a lot of USCIS offices closed and we're not handling interviews or applications or anything for that matter. So they accrued a lot of backlogs. And last year, they were able to process 10 million cases. That is huge. Okay. That is huge. That means that hopefully if they continue on the same trajectory, that they're going to be processing applications faster going forward. We already see that with the citizenship applications where they are scheduling interviews within like 6 months of applying. So it is one of those things that we want more of that, right? We want them to continue to chip away on that backlog so that people can actually get their interviews faster, get their cases processed faster. So citizenship applications have definitely sped up, and I-130 green card applications. So when you are applying in the US for your green card, we've seen that those go faster as well. So it is great news. And we're just hoping that they continue on the same trajectory, especially with the fee increases, right? They're increasing the fees, so they're going to get more money out of the applicants. So they should be able to continue increasing staff, increasing their capacity so that they can actually process these applications faster. Again, if they're going to increase fees, we expect results better than what it is today. So, great news. Backlogs are reducing at USCIS only. The embassy, completely different deal. They're still working through their backlogs. Some embassies are doing a better job than others. But definitely a good thing at USCIS for those backlogs to be going down, because that means applications that are pending can be processed faster. All right. And then the final thing I want to tell you all is the re-parole for certain Ukrainians. So if you are from Ukraine, you came into the US with parole, um, or you got parole while you were in the US on or after February 11, 2022, you can apply for re-parole. Basically, you can apply to USCIS using Form I-131 to say, hey, I would like more parole, right? I would want you to reissue my parole, because again, those paroles were lasting for 2 years, and most people may not have a way to go from having parole to something else, or their asylum applications are still pending. They haven't had an interview. They may need that parole. So Getting re-parole for Ukrainians means that they can now have additional time as parolees into the US. So you have to show that you were paroled on or after February 11, 2022. You also have to show that there is still urgent humanitarian reasons for you to remain paroled. I think that's an easy one for most Ukrainians in the US to show that there's still urgent humanitarian reasons for the parole to be reissued. You have to show that you are a candidate for favorable discretion. This typically means that you have not committed any crimes in the US and you have complied with the conditions of your parole. So those are two of the things that you still have to show. And of course, pass background checks. Make sure you are following the laws of the US. And if you're able to show those things, you can get re-paroled. So you will need to file an I-131. And once once that parole is approved, you can then apply for a work permit based on the parole. Okay. Do not apply for the work permit at the same time as the I-131 because it's just going to be denied. But if just have to wait until that I-131 is approved, and then you can apply for the work permit, the I-765. All right. If you have questions, please go ahead and put it in the comments. If you are getting value out of this video, please go ahead and hit the like button. And if you're joining me and you have questions about this or other immigration topics, feel free to put it in the comments. Hi, Gonzalez. Hi, Ade. Thank you for joining me. Again, feel free to ask me questions. I'm just going to go through the updates again. The fee increase is coming April 1st. So get your applications in before April 1st. It has to be received by USCIS before April 1st. If they get your application on April 1st, you better have included that new fee or they're going to reject your application. All right. There is a new policy for visa overstays that want to apply for change of status. So that is going from, let's say, a B2 visa to an F1 visa. So if you already overstayed your B2 visa because of exceptional circumstances beyond your control, you may still be able to get that change of status to an F1 if that's what you would like to do. This is a new policy. It's great. It gives people more options to restabilize their status in the US. USCIS has reduced their backlog. They processed 10 million cases last year. That's 10 million cases that led to a decision. So it's not they accepted 10 million cases. They usually do more than that. But they actually finished 10 million cases last year. That is a big deal because it's the first time in a long time that they're actually reducing their backlogs. So that means we are expecting cases to be processed a bit faster. And then for Ukrainians that had parole on or after February 11, 2022, you can apply for re-parole with Form I-131 if you can still show that there's urgent humanitarian reasons, favorable discretion, you complied with the conditions of your parole, and you can pass background checks. You can then apply for the I-131 and get re-paroled. All right, so I see a question from Michael. Can follow to joint asylee be changed to I-130 family petition at consular services? No. So so basically whatever petition you have pending is what you're going to be interviewed under. So if the person received an approved I-730 and now they are in the consular process, they are only going to be processed based on the I-730, not the I-131, unless so there's also situations where you can ask the embassy to expedite the I-130 visa interview. So let's say, for example, the the asylee um, has been scheduled for an interview, but the I-130 has not been scheduled for an interview at the embassy. You may be able to convince the embassy to do both or to switch one with the other. So the it's just the I-130 has to be completed, right? It has to be approved. You cannot have an I-130 pending and the embassy will not make that change if the I-130 is not already approved, and if the DS-260 and the affidavit of support and all of that is not already done. Okay, so you want to make sure the I-130 is approved, and also make sure that the consular, the MVC stage is done, and that you have been documentarily qualified before you request that change. But it's really up to the embassy. We do it when we do request some of those changes when, let's say, one family member is scheduled for an interview and another one is not. Sometimes we're able to convince the embassy to schedule them together. So you just have to make sure that you have all your other things together, right? Your documentarily qualified I-130 is approved, and then request it with the embassy. And sometimes they may be willing to do that. All right. Shed some more light on change of non-immigrant visa B1 to F1 or H1B visa. Okay. So if you are in the US and you came in with a B2 visa and you want to switch to an F1 or H1B, for an F1, you need to get admission into a school in the US. So you need to contact the school, file an application, get admitted into the school, and be issued an I-20. That is a must. So whether you're applying from inside the US or outside of the US, you must have an I-20. In order for the school to issue you the I-20, you have to show that either you or a sponsor has the money to pay for your education. Okay, and that's pay for it in full, not partially, but pay for it in full. So that's how you start the process for the F1. And then once you have your I-20, you can apply for a change of status, the I-539, from B2 to F1. File that with USCIS, and they will be able to process your application. You do have to include documentation that you're able to pay for the school and yourself to live in the US. All right. You can do that online or on paper. If you do it online, you can also choose to do premium processing, which will make USCIS process it way faster. Typically within a couple of weeks, you should have some form of communication from USCIS on whether they need more documentation or if they approved or deny your application. So that's the change to F1. And then the change to H1B, you need an employer that's willing to file an H1B lottery for you. You have to win the lottery, okay? The H1B is not just a straight application. You have to win the lottery and then do the change of status. So depending on how much time you have in the US, you may not have enough time to do that. All right. The H1B, I believe, just opened or is opening soon. So if you don't already have an employer that's going to be entering the lottery for you, you may want to do that now, unless you are working with a university, a nonprofit that may be exempt from the lottery, then they can do it at any time of the year and be able to get you that change of status. If you have overstayed, so everything I just talked about, doing a straight change of status with the I-539 is if you have not overstayed your visa. Okay, if you have overstayed your B2 visa before, I would be telling you that you are out of luck. You're not able to do a change of status. However, with the new USCIS policy, if you have overstayed your visa, but you only overstayed due to circumstances beyond your control, exceptional circumstances beyond your control, you can still apply to change your status. So if you already have the I-20 and the reason that you didn't file before your stay expired was, beyond your control, something major happened, you had an accident, you were in the hospital, something happened that was beyond your control, so you couldn't do your change of status, well, now you can still apply for the change of status with documentation showing the exceptional circumstances, okay? And then it's up to USCIS to decide whether to approve your change of status or not. The longer you are out of status, the harder it's going to be to show the exceptional circumstances, okay? This is something to keep in mind. If you have been out of status for a month or less, it's probably going to be easier to convince USCIS that it was beyond your control. The longer you are out of status, the harder it's going to be. So, Ade, I hope that answered your question. If anyone has a question, please put them in the comments. I am more than happy to respond to you. All right. And remember, if you are doing a change of status, that you are including documentation that shows you can actually afford to remain in the US and shows that you are, if you're going to a F1, which is the student visa, you have to show that you have enough money or your sponsor has enough money saved up that they can easily pay that. If your sponsor is not a family member, I typically recommend that the sponsor include a letter explaining why they would want to even sponsor you, right? If, let's say, your sponsor is your parent's cousin, USCIS may wonder, why would this person want to sponsor you and spend all this money? Because US colleges are not cheap for international students. So even though you're going to be in the US, you're still considered an international student when you do a change of status. So you're going to be paying that international student fee. So if someone is going to be sponsoring you and it's not a parent, it's not a sibling, they may want to include just a letter explaining why they would be willing to spend that kind of money on your education. All right. Hi, Zeus publishers. Let's see. My spouse do not work and she's 26 years old. She hasn't filed taxes before. Does she still qualify for Form I-864? So, okay. He added that she is a US citizen. She is going to need a joint sponsor. Okay. She still has to file a Form I-864 because she's the petitioner. She can just show she doesn't have any income. However, in order for the I-485 or for the visa application to be approved, you would need a joint sponsor that's willing to file an I-864 for you. Okay. So is it okay? Yes, we've done this before. You just need to make sure that you have a joint sponsor that has enough income and is willing to complete the Form I-864 for you. Okay. Hi, Indeed. Okay. Hi, everyone. I am preparing to submit the I-130 for my spouse. We finally just got married. We finally just got our marriage certificate from Lebanon, but it seems they put the incorrect date off by 1 day. All right. So here's the thing. You need to contact them to change that. And also, keep in mind, in certain countries, depending on the date, so let's say you got married on July 6th, 2023, right? In certain countries, they're going to write it, like in the US, it will be written as 7/6, 2023. And then in certain countries, it's going to be written as 6/7, 2023. So just make sure it's not that. issue before you, because sometimes getting documentation from outside of the US is more of a headache than you hope for. So just make sure that that's not the mistake. And if that's definitely not the mistake there, then you will have to contact them. And also, some countries, the day that you do your ceremony may not be the day that it is registered. Okay. So think about that as well. So just confirm those two things, that the dates are not transposed in that country. So they, make sure that it's not that they did the month, year mixed up, and that in that, that in Lebanon, they register the marriage the day that it happened, that the ceremony happened. Okay, so depending on when it's registered, that may be the date that they have on the marriage license. So just confirm those two things. And if those two things are not the case, you will need them to change the marriage certificate to actually match when you got married. All right. Next question. How long should I wait? Good question, Sus. How long should I wait to file from I-130 after marriage? This is a great question because people always ask me this, and the answer is you don't have to. That's literally the answer. You don't have to wait. Oh, you're welcome. You don't have to wait because, I tell people this, you don't have to wait because you just have to show proof of your relationship. Right? You have to show proof of your relationship. And sometimes what I do for people that want to file right away is that proof of your dating relationship is also proof of your relationship. Okay. Just so you're going to have some time to build up those other documentation. So let's say, for example, you and your spouse decide to get married and then move in together. You can update your lease once you finally move in together and all those things, and get the joint bank accounts, get bills in both names, things like that after you move in together. That's completely fine. USCIS understands, especially when they see the marriage certificate and they're like, oh, they just got married. They understand that you're not going to have a lot of things together, but just know that when they get closer to either scheduling you for an interview or making a decision on your case, they may excuse me, they may send you a request for evidence. One second. Ooh. They may send you a request for evidence for more documentation of your relationship. So you want to make sure that, if you're filing right away, that you don't forget that you still need those things, because USCIS, if they schedule an interview, you want to take those things with you. If they send you a request for evidence, you want to have those things to send in. But typically, you don't have to wait. It's really up to you what you feel comfortable with, but you typically do not have to wait. All right. So question from Instagram. Does a first-time DUI that did not result in a conviction but ended up being a supervision affect a valid case that had been pending for 42 months? Okay. So if this is a new DUI if it did not result in a conviction, USCIS may let it go, right? Because they usually look at the conviction. So if it was a conviction, it may affect the good moral character part of a VAWA case. Okay. You do want to be ready with the certified copy of the court disposition, because once they get ready to make a decision on the VAWA case, USCIS will most likely rerun the background check, and that's going to come up. And they're most likely going to send you a request for evidence for the court disposition, and you need to send them a certified copy of the court disposition so that they can see that it wasn't a conviction, and then they can make a decision. So it can be a problem if the officer decides to make it a problem for the good moral character. But because it wasn't a conviction, you have a better chance of them not making it a problem. Okay. All right. So if you're joining me and you have questions, put them in the comments. If you are getting value out of this video so far, go ahead and hit the like button, just so I know that you are getting value out of this, and I can continue doing these news updates and, of course, the Q&As that we do. So I do not see any new questions. I just want to thank you all so much for joining me. I truly enjoy answering your questions, giving you the updates. You already know whenever there's a new immigration update, I am going to be giving it to you, because it really does make a difference when you are planning, right? When you're planning your immigration journey, you want to have all the relevant information so that you can make the best decisions for yourself and your family. If you would like to schedule a strategy session with me, if you're going through your green card journey or your citizenship journey, and you just want to get some expert help with the process, go ahead and schedule a strategy session with me. You can do that by going to my website, lilylegal.com, or by calling my office at 508-443-1788. All right, I see another question. How many forms do I, this is great. How many forms do one need to file for marriage-based green card? Well, I have a whole video on YouTube on the marriage green card forms and all of that, but quick breakdown. For a marriage-based green card application, you need an I-130, an I-130A, an I-485, an I-864. Those are the required documents. If you want a travel permit or you want a work permit, so the work permit is the I-765 and the travel permit is the I-131. So if you want those, you need to include those additional forms. But really, it's just those 4 forms with the supporting documents, because trust me, you want to make sure that you're including all the supporting documents. And if you're doing a brand new green card application case, just know, if you file after April 1st, so if you file April 1st and after, you're going to be paying close to $1,000 more, actually more than $1,000, because right now the fee is $1,760 for all the forms, including the work permit and the travel permit. And then after April 1st, if you want to include the work permit and the travel permit, you're looking at $3,004. So if you want to start that process and pay significantly lower, go ahead and file and start that process before April 1st. For our clients, where we're moving, we're letting everyone know what the cutoff is and what that extra fee is going to be, so that they're prepared for it and they can decide whether they want to actually file now or wait and file later. So just make sure that if you want to save yourself some money, to file before April 1st if you can. Okay? File before April 1st if you can. All right. I do not see any other questions. Thank you all so much for joining me. I will see you next week for more immigration conversations. Bye.